Hi, everyone. Harry here to talk about a decision by a court of appeals, the First Circuit Court of Appeals that sits in New England, declining to give relief to the government that had asked for it to revisit a decision by a district court saying, government, you revoked the status of 400,000 people who had been given a 2-year reprieve from the Biden administration. You cannot do that willy-nilly. The statutory scheme requires you to do it in a case-by-case way, just as the statutory scheme requires parole to be granted in a case-by-case way. Okay, so that's the bottom line, and let's double back a little bit. There's a lawsuit pending in a district court in Boston. And Judge Talwani, if you think it's important to keep score, an Obama appointee, and by the way, so are the 3 judges from the First Circuit who heard this appeal. Judge Talwani, as it was pending on different immigration claims, the Homeland Secretary, Kristi Noem, basically said there are these 400,000 immigrants and they've been granted a 2-year parole. We changed our mind. We're just wiping it out in a fell swoop. And Talwani said, you cannot do that, and granted first this temporary, we're pretty familiar now with the early machinations in the case, temporary restrictive order. At that point, the administration trots up to the Court of Appeals. That's the First Circuit, considered relatively progressive as the courts of appeals go. And that's who heard the case and issued a decision yesterday. It's pretty straightforward. There's not a big dissent, and there's not even a big majority. What it basically says is, look, you lost below, and now, like so many of these cases, they turn on the particular legal requirements for preliminary showings and emergencies and getting things undone and the irreparable injury and the like. And what the First Circuit said is, it's clear from the statutory scheme, you can only give parole case by case, and it's pretty darn clear. That's basically as much as they had to say for these purposes, that in the same way you need to revoke parole. You can't simply do it without a reason. It's so often what the administration is trying to do. What's their reason? It's an immigrant. That's the reason. Not that anyone is, notwithstanding that Trump rhetorically loves to play the card that we're being overrun with immigrants who also are adjudicated or not adjudicated, just murderers and terrible criminals. It's just not who we've been talking about. Largely, they've been, trying to get at low-hanging fruit, just people who have, in their minds, imperfect status. So that's what happened here. And the First Circuit says it's clear. And it is clear that to put him on parole, you did a case-by-case determination. The Biden administration sort of cleaved out specific category that with criteria that the 400,000 qualified for. Kristi Noem just goes in and says, no, because they are illegal immigrants and because Trump was elected to do this job, et cetera, we are saying we are just revoking it, boom, probably preparatory to ousting them from the country. But the district court puts it on hold, and now the Court of Appeals says, looks to us as if it probably has to be case by case. They point to statutory scheme that talks in terms of he and seems to be identifying individual immigrants when you're trying to revoke parole. And that is enough for now not to. You haven't shown government a likelihood that you're going to be able to prevail. On the contrary, the likelihood looks that you're going to lose because the district court's argument and reasoning is sound. We don't have to find that you've lost for now. We just have to find that you haven't given us enough to undo what the district court has done. So now it goes back to the district court, and the district court will continue to follow through. As so much of the administration's attempts to scream emergency, what could happen here? What could happen here is the district court follows through, finds that it has to be case by case, grants an injunction, a permanent injunction, and then the First Circuit, including the possibility of going en banc, including the possibility of the Supreme Court, decides straight up on the merits, rather than simply saying, you haven't given us a reason to do this via the emergency route. Okay, so that's the story. I just want to add to it. We have these cowboyish appointees who, even as Trump he goes back and forth. I respect the Supreme Court, but I don't know what the Constitution is, and nobody's going to tell us we have to do 500,000 due process trials. Of course, that's what due process means. An individual gets it. If you need more judges, get more judges. But in a similar way, so we have Homeland Security Secretary Kristi Noem, and here's what she said. Of course, they argued she had the discretion to categorically end their status. That's what was rejected. And now here's what the Homeland Security Department spokesman said in a statement. So that would have been, cleared, and it's the official statement of the department. The Trump administration is committed to restoring the rule of law to our immigration system. Excuse me? The rule of law here is as determined by courts, and it's specifically that you cannot simply in one fell swoop try to just get rid of and change the parole status of immigrants. That's the very soul of the rule of law. You've got a ruling. This happened, by the way, right, with Abrego Garcia. He has a ruling before that said, do not send him to El Salvador, which they ignored. Sometimes they say because they screwed up. Sometimes they try to justify. But that's where the law points. Same thing here. But here's the statement I want us to reflect on. So the spokesperson said that, then continues. No lawsuit, not this one or any other, is going to stop us from doing that. One hand, you could take that as just rhetoric and chest beating, but if you give it just a second's thought, it means they're saying we're not going to follow the courts. And so we're back plunged into constitutional crisis territory. It does seem at one point or another, this showdown is coming. This is the First Circuit Court of Appeals, mind you. This is up there just below the Supreme Court. They're saying, no lawsuit, not this one or any other, not even one that goes to the Supreme Court, is going to stop us from doing that. That is the saber rattling that happens in response to this holding, where they rejected the assertions of the Homeland Secretary of the Homeland Security Department, what the rule of law requires, and instead they're saying no one's going to stop us. Query what the hell that means going forward. For now, they can try to seek renewed emergency appeal in the Supreme Court, or go through the trial, and then go up. That's what the rule of law provides. And, they're trying to say at the end of the road, we don't care. That's what you call an authoritarian government, not regulated by the rule of law. That's what you call an authoritarian government. That's what you call the potential end of the American experiment. So that's who we have now in charge of the levers of government. We'll see how strong and hard they follow through. For today, they are parried and told firmly, forget about it. Go back and adjudicate these one by one, or else try to appeal our ruling now. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.